Well, our next guest is Daniela Simionovici. She is the Vice President of ASCPD Romania and Senior Partner at VACY Romania. Her presentation is about implementation of the NIS Directive in Romania, common ground with GDPR. Daniela?
Thank you, Diana. Good afternoon, everybody. My name is Daniela Simionovici, and I'm the Vice President of ASCPD. I will spell all the acronyms as in Romanian, with your permission. It's much easier. And I'm Senior Partner to VACY Romania. I would like to thank all the guests, all my colleagues in this panel. They had extremely interesting presentations. And I'm glad to participate in this first national conference on privacy and data protection, VACY Romania. And my presentation, as Diana said, it will be about the implementation of the NIS directive in Romania, common grounds with the GDPR. Why the NIS directive? Because the NIS directive is only one of the many directives that were approved and applied since now, and furthermore to come, that will intertwine with the GDPR. Now, the adoption of the Directive 1148 from 2016 of the European Parliament and of the Council of 6 July 2016 concerning measures of a high common level of security of network and information system across the Union reflects the constant concerns of the community authorities in recent years regarding the increasing resilience of IT and C infrastructures belonging to the operators of essential services and digital service providers in the member states. The NIS directive lays down measures with a view to achieving a high common level of security of network and information systems within the Union so as to improve the functioning of the internal market. As you can see, Sherban, my presentations is all about TOMs. So it will be a very interesting way to see how, but it's actually more about the as I said, more about the networks and information systems, not generally TOMs, but specifically on networks and information systems. The NIS directive is not a new cybersecurity law. The NIS directive is not about national defense and security. The NIS directive targets the market and services. The directive focuses on the risks posed by the security incidents to the conduct of economic activities, the potential financial losses that companies, citizens, or administrations of the member states may incur, and the intentional or unintentional disruption of network information systems that support essential services for society and which may affect several member states at the same time. As you can see from the beginning, this directive talks about potential disruptive effects of security incidents that may affect several state members and not just an individual or only one member state, as a difference between the NIS and the GDPR. The transposition in the national legislation of the NIS directive was made by Law 362 by 2018 on ensuring a high common level of security of networks and information systems and entered into force on 12 January 2019. The normative act has a special importance for Romania because it transposes at national level the NIS directive number 1148 by 2016 and aligns Romania to a common European framework of responding to cybersecurity incidents. Simply put, the implementation of the provisions of the NIS directive by transposing them into national NIS law creates a framework to ensure the continuity of essential services whose provision depends on network and information system. This is a very common, a very important concept of the NIS directive because let's say that all the TOMs we talked before are focused on this dependence on network and information systems. I will analyze the provision of essential services insofar as the provisions of the NIS directives and intertwined with those of the GDPR. The importance of personal data protection from the perspective of the NIS directive can be immediately noticed from the fact that one of the first articles of the directive, more precisely Article 2, refers to the protection of personal data. The Law 362 by 2018 applies to entities providing services in the following sectors: energy, transport, banking, financial market infrastructure, health sector, drinking water supply and distribution, and digital infrastructure. We can easily identify the sectors in which a large volume of personal data is processed, such as the sector that supply electricity, natural gas, or drinking water to final beneficiaries, the banking sector or the financial markets infrastructure sector, as well as a large volume of personal sensitive data, such as health data and more. For example, regarding the segments and the way in which the NIS directive and the GDPR law intertwines, I will use, for exemplification, the health sector. In Romania, the National Cybersecurity Incident Response Center, CERT-RO, is the competent national authority for the security of networks and information systems that provide essential services or provide digital services identified under the NIS law. By Order 601 from 2019 for the approval of the methodology for establishing the significant disruptive effect of incidents at the level of network and information systems of the operators of essential services, no thresholds or limits were set for the health sector, and consequently, no threshold values are established for a certain service, which shows that the degree of disruptions resulting from the interruption of the provision of essential services in the health sector is significant, namely high. Even if there are operators in the medical sector whose activity does not depend on a network or an information system, such a dental office with a single dental unit which uses only one phone for patients' appointments and has not signed a contract with the National Health Insurance House, therefore the provision of the medical services and its payments does not depend on an internet connection and an application connected to the National Health Insurance System. The simple fact that no threshold values have been provided for this sector means that all operators in this sector are operators of essential services, OESs, and the services provided by them are essential services, ES, and fall under the provisions of the NIS law. Therefore, any disruptions in the provision of these services is considered to have a significant negative impact in the community, society, and operators are required to ensure a high level of security of the network and information systems they use. Networks and information systems are no longer used in a hospital, for example, only for the administrative management of its activity, registrations of patients, management of medical procedures or medicine, preparation and issuance of medical documents, intra-institutional electronic communication, etc., but are also used for the activation and use of configurable devices, including computed tomography systems, ultrasound systems, anesthesia systems, physiological monitoring systems, radiological information systems, or for activating, control, equipment and devices, and management of access to operating rooms. Access might be allowed on the use of a personalized access card, and the opening of a door might depend on an application computer system, but also on the power supply. Therefore, even if network computer system is not the victim of a hardware malfunction or a cyber attack, may be the victim of a common power outage, with equal significant negative effects, especially when the interruption of the provision of essential services, even for extremely short periods, can make a difference for a patient in serious conditions, regardless of whether the interruption was due to a broken computer, a frozen application, or a power failure. The common and largest ground on which the NIS and the GDPR Act meet and interfere is that of technical and organizational measures for the security of network and information systems. Both legislative norms have clear provisions regarding the aspect of ensuring the security of network and information systems, which, in the case of NIS law, refers to ensuring the continuity of essential services under Article 10, Para 1, letter B of the NIS law that states, operators of essential services implement appropriate measures to prevent and minimize the impact of incidents that affect the security of the network and information systems used for the provision of these essential services in order to ensure the continuity of those services established under the provisions of Article 25, Para 3. And in the case of GDPR, it refers especially to the compliance with the principle of integrity and confidentiality, Article 5, Para 1, letter F, GDPR, which makes explicit references to the fact that personal data are processed in a manner that ensures appropriate security of the personal data, including protection against unauthorized or unlawful processing and against accidental loss, destruction, or damage, using appropriate technical or organizational measures. Both legislative norms have clear provisions regarding the identification and notification of security incidents. But in this chapter, there is also the first difference between the two normative acts. GDPR applies to security breaches that generate accidental or unlawful destruction, loss, alteration, unauthorized disclosure of, or access to personal data transmitted, stored, or otherwise processed, Article 32, Para 2, GDPR, regardless of the number of data subjects affected. While according to the NIS law, operators of essential services immediately notify CERT-RO as a National Computer Security Incident Response Team of incidents that have a significant impact on the continuity of essential services by providing at least information provided in Article 26, Para 3. Now, the significant impact on the continuity of essential services could imply that if the incident did not fall into this category, significant impact, there would be no obligations to notify to CERT-RO. On the other hand, giving the zero threshold value for the health sector mentioned above, it would follow that any security incident resulting in the interruption of the provisions of medical services, regardless of the number of patients affected, should be reported to CERT-RO. For example, if the interruption of the provision of medical services endangers the health or the life of even a single person or results in the death of a patient, we consider that we are facing a significant impact of the security incident. It is unclear, however, whether the CERT-RO notification is required in this scenario of only one patient affected or not. It is also unclear whether the interruption of the provision of essential services in the same scenario proposed by us falls into the category of security breaches and requires notification of the supervisory authority, given that we could face a situation where personal data availability is affected. Another common segment on the two normative acts is that of notification information to data subjects under GDPR or general public under NIS in case of an incident security breach, but the common ground stops here. In the case of NIS law, Article 29 states that CERT-RO may notify the public when information is necessary to prevent an incident or to manage an ongoing incident. For incidents affecting an operator of essential services or digital service provider, the information referred to in Para 1 shall be carried out after prior consultations with him, she, on the content of the notification. We consider that this provision of the national law is a transposition of recital 59 of the UN NIS directive, which states that publicity of incidents reported to the competent authorities should duly balance the interest of the public in being informed about threats against possible reputational and commercial damages for the operators of essential services and digital service providers reporting incidents. We note that CERT-RO may notify the public for the prevention of a security incident or for the management of an ongoing incident only after consulting with the operator of essential services on the content of this notification. That meaning on what and how much can be made public. With regard to the notification of the data subject, the GDPR is much more sharp and obvious in favor of the data subject. And this can be easily seen in the official statements on the GDPR fines imposed, in the sense that the controller's reputation seems to be the last concern of the national supervisory authorities. In order to support all those targeted by the NIS law, but also practitioners in personal data protection, together with my colleague Marius Dumitrescu, I developed for the first time in Romania a course support that was, in fact, the basis to my presentation today. The implementation course of the NIS law that we propose also involves a certification which can be obtained by passing a test based on 100 questions from the NIS directive, from the law 362 by 2018, from our course support, but also from the other normative acts and guides provided by CERT-RO. The course support is very detailed and explicit and is made from the perspective of the practitioner, who is obliged to always answer the question, how do I apply what the law requires? The answer to this question under the NIS law is very similar, moreover, with respect to the principle of responsibility in GDPR. Thank you all. And if you have any questions, I would be very glad to answer them.
Looks like we have a question from Marius. Can you please tell us if you interpret that the NIS directive is applicable to NFI?
I can't simply answer this question bluntly.
From chat. Sorry about that. It's not from Marius.
Excuse me. I haven't heard.
The question is not directly from Marius. It's from someone else from our chat.
Okay, I understand. Now, I can't bluntly respond to this question for the simple reason that you need to perform a very thorough evaluation under the NIS directive to first find that if you provide essential services, that you are operator of essential services or not, and only then, if you, for example, find your entity that provides services that follow into that there is a list of essential services where you can for the first time check if you find yourself there. It's a very large process of evaluation, and I can't answer simply without making a proper evaluation. So that's why I will not answer to this. If, for example, NFA falls under the NIS directive, under the NIS law, it's a process that has to be made thoroughly, and I won't risk an answer, because it depends very much on the fact that you provide or do not provide essential services.
Good to know that. Thank you so much, Daniela. Looks like we don't have any other question. Thank you so much for your presentation and for being with us today, and for all your questions to all the other guests.
Thank you.